Hi guys, Alena Shautsova, immigration attorney from New York is here. In today's video, I'm going to be talking to you and sharing with you information with regard to the immigration courts and what's happening in immigration courts. If you are in removal or deportation proceedings, or in other words, your case is pending in immigration court, you may have noticed that your case was taken off the calendar. Meaning that when you are punching in your A number into the electronic automatic system, or when you call EOIR 800 number, you receive information that there are no future hearing dates set for this case. Who would be to blame? Your luck, your lawyer, or what's going on? So today I will try to answer these questions for you, and we're also going to talk about some other interesting topics and things that are happening. So thank you very much for watching me. My name is Alena Shautsova. I'm a practicing immigration lawyer from New York. I also help people in all 50 states and overseas. So there is no real mystery as to what's going on with immigration court cases. What's happening is that there was a memorandum that unfortunately was not public, sent to immigration courts, judges, advising them to take certain cases off the calendar. I have reviewed certain practice pointers that were shared with attorneys by the American Immigration Lawyers Association, and I have to say that I have experienced, or my clients rather have experienced, this phenomena when your case is taken off the calendar, and it would not be due to the specific criteria mentioned in this secret memorandum. The memorandum primarily refers to cases that are not ripe for adjudication because, for example, a person is waiting for collateral relief. The person is waiting for the sponsor petitioner to become of age. The person is waiting for I-130 or some other underlying petition either to be approved or the priority date to become current. And in those cases, courts, on their own initiative, are going to take your case off the calendar, and you will not see your future master or individual dates. However, what's interesting is that I have the same situation happens to some of my clients who do not have any collateral or future relief based on a petition by a family member or based on a petition by an employer. And let's say a pure asylum case where a person does not have any other relief except for asylum is also being taken off the calendar. Not all of them, but some. What can you do in this situation? Well, first of all, you need to answer this question. Do you want to do something about this situation? Or perhaps you or your client is better off waiting in the United States. Perhaps the situation is that they need this time to try to find alternative ways to adjust their status, or perhaps they are waiting for something, but it's not decided yet. For example, I have clients who are planning on getting married. They do not have a set date yet when they're going to get married, but they do have those plans. And for people like that, this situation is probably plainly ideal, but not for everyone. So if you are in a hurry and you believe that you'll be better off if your case is being heard soon or now, you may file a motion to put a case on an active calendar and to advance the hearing date. I rarely suggest that to a client because usually it would go against their interest, but it's a possibility. Another quite interesting thing that I wanted to share with you concerns prosecutorial discretion in courts. Just recently, a couple of days ago, United States Supreme Court did not approve stay of the Texas judge's decision to block Biden administration from exercising prosecutorial discretion according to the memo that was issued in September of 2021. I must admit it was quite a shocking decision by the United States Supreme Court to restrict the administration's powers to exercise their prosecutorial discretion on a mass level, but at the same time, you should not be discouraged. The only difference for you is this. If during the time when the prosecutorial discretion memo is in effect, prosecutors may, on their own initiative, exercise prosecutorial discretion, at the times when the memo is not in effect, now, they may still do so on a case-by-case basis. Only an affirmative request is needed. It means that you or your attorney, rather than waiting for the prosecutor to review your case on their own, you should submit the request for prosecutorial discretion. And usually it is done by uploading the request through a special system where the prosecutors are going to automatically register it in a queue, and they will review the request when they are available. Usually it happens very quickly, within a week or 30 days. Sometimes it may take up to 90 days. This would be the usual time frame to hear back from a prosecutor with regard to your prosecutorial discretion request. Well, thank you very much for watching. I hope my updates are helpful. If so, please like, share this video, and I hope to see you soon.